up, if you can just vote and then submit your vote, and then we'll do a results on the end as well. And I'll hand you over to Tom. Thanks very much.
Great, thank you, Tom. Welcome to the Freeths HR Matters Defending Employment Tribunals webinar. My name is Tom Draper. I'm the head of the employment team in Sheffield, and I'm also joined this morning by managing associates Toby Pochron and Elizabeth Ferguson. We are 3 of the 5 people that make up the Sheffield employment team. We also have newly qualified Lee Williams and Sahar Hamer as well, who's our legal assistant. We decided to look at defending employment tribunal claims this morning because for a lot of our clients, employment tribunals are very scary places, and a lot of them, they're very unknown places as well. If you don't have experience of dealing with employment tribunal claims, then they can be quite intimidating. Whereas other clients relish the cut and thrust of litigation. And we thought that by sharing our knowledge and experience about dealing with employment tribunal claims, this would put you as the client and the employer in a much better position to decide on an informed basis about the risk analysis that you're doing on a day-to-day basis. So if you know a little bit more about the process, then you're in a better position to make an informed choice about how you proceed with potentially litigious situations that you get in the workplace. So when people think of employment lawyers, often they associate us with litigation, but that's actually only about 1/3 of what we do in the Sheffield Freeths employment team. We also draft contracts of employment, policies and procedures, and we do a lot of HR support work as well. So advising clients about how to avoid tribunal claims. So that's the breakup of our kind of workload, but a lot of it does still involve defending employment tribunal claims. And at the moment, there is an upward trajectory of tribunal cases. The last available quarter showed an 18% increase in individual claims, and that was the quarter till March. So that doesn't even include the coronavirus related cases that we're seeing coming through already. And these relate to a lot of things that you might expect, furloughing employees, changing terms and conditions, redundancies and restructures that have been thrown up as a result of coronavirus. And in essence, we expect to see the upward trajectory of claims continuing over the next year as all these claims kind of filter through into the system. And that's the top and bottom of why we've chosen the topic this morning. Because it is very topical for a lot of our clients. The most common claims are those for equal pay, unfair dismissal and unauthorised deduction from wages, with unfair dismissal being the biggest one there. There are some basic steps that you can take to reduce your chances of receiving an employment tribunal claim. If you've got good policies and procedures in place, and you stick to those policies and procedures and you treat your employees fairly, then there's a really good chance that you're going to avoid litigation. Having said that, there will always be rogue employees and difficult characters. And I'm sure that as HR managers, you're all very familiar with the odd difficult character that comes across your desk to deal with. And these are the people that potentially are going to be the ones that bring employment tribunal claims. And obviously the size of your business also affects how likely you are to receive a claim. Obviously, the more employees you have, the more likelihood there is of that. So we thought it would be a good idea, just so that we could get a sense from you guys watching the webinar and an understanding of how much experience you've got about defending employment tribunal claims, to do a poll. And as Tom just mentioned, we're gonna do the poll now so that we can kind of tailor the content of the webinar accordingly. So you've got the question there on your screen. It'd be interesting for us to know how many of you have dealt with employment tribunal claims, either yourselves, with the help of lawyers, or those of you that haven't had the pleasure of having an ET1 land on your desk. So I'll just give you a couple of minutes to vote there. Okay, so we've got 36% of you have defended employment tribunal claims with the help of a lawyer, and 64% of you haven't had the privilege of doing that. So it's interesting to see that no one's tried it on their own. So that is an interesting statistic. It is difficult, and there are tricks of the trade that we're going to go into some detail about in this webinar. We would, however, say, and we would do this obviously as lawyers, but there is a huge benefit to having lawyers involved and using their skills and experience to draw on in the defence of an employment tribunal claim, because there are some simple things that you can do to increase the chances of a successful outcome and reduce the chances of an unsuccessful one. So I'm going to try and remove the poll now from the screen. So that is defending employment tribunal claims. So I'm going to now look at the overview of this morning's session before I pass over to Toby. So before you get an employment tribunal claim, there is often a chance to conciliate with the employee through ACAS. We're going to look at that. Then there is the response and any preliminary hearing that might be had, and looking at the tribunal orders that can be made, how to draft and exchange a witness statement, what the potential outcomes are, and then looking at the practicalities and how things have changed in terms of tribunal litigation in the COVID era. So I'm going to pass over to Toby now, and he's going to tell us a bit about ACAS conciliation and time limits.
Marvellous, thank you very much, Tom. Good morning, everybody. So after that fabulous introduction, yes, I am going to be running through some time limits, looking at ACAS early conciliation, and then considering how to submit a response to a tribunal claim. So the first port of call for us, whenever any of our clients receive a claim in, is we'll always look at considering whether or not it's been submitted within time. So all that simply means is, in accordance with the current legislation in employment law, in accordance with the tribunal rules, a claimant has to submit any claim within the relevant time limit. The vast majority of claims in the employment tribunal need to be submitted within 3 months of the date of what we would call a cause of action. So the date of a claim, the date upon which they were dismissed, the date upon which they were underpaid, the date upon which they are saying that they suffered some aspect of discrimination. The clock starts ticking at that point, and they've got 3 months to advance that claim. Now, the time limits in the employment tribunal are a hard and fast rule. You know, they're born out of legislation. Legislation says you've got 3 months to do it. You've got to do it in that period of time. And it's designed to ensure that employers aren't put to a detriment. So it's designed to ensure that an employee, if they've got a claim, they bring it quickly. And also it puts the parties on an equal footing, because it allows the employer to ensure more likely that they will have staff who will have knowledge of the claim, who are still with them. They will have staff who can provide witness statements. The manager who maybe took the action to dismiss is most likely still going to be with that employer within a 3 month timescale. But equally, the tribunals run on fairly swift turnarounds when considering kind of other litigation, which might take a couple of years. Tribunals normally are dealing with things between 6 and 9 months, kind of depending on the complexity of the claim. That's also on the basis that an employee might be out of work at that point, probably wants a quick remedy. It's designed to move everything along quite quickly. Now, the tribunals don't like it if a claimant submits a claim out of time. Normally, what will happen if a claim is submitted out of time, it simply gets knocked out by the tribunal system. So you might actually never come across it. So if that individual just misses the deadline, doesn't know about the time limits, gets them wrong, incorrectly starts it all off, the judge or the tribunal clerk will normally catch that at first instance, and it won't get transferred on to anybody. It simply gets sent back to that individual and says, well, why did you submit it out of time? Unfortunately, it's not the end of the story, because a claimant can submit it out of time and say that it wasn't practical for them to submit it within time, or they're bringing a claim for discrimination and the tribunal can extend those time limits. I saw a case a few years ago that was submitted 18 months out of time, because the chap had a rather serious mental health condition, and a judge agreed with him that he couldn't contemplate bringing the claim until 18 months later. That's probably the most extreme example that I've ever seen. But there is that discretion from judges. So normal rule is you got 3 months to start it off. Now, it used to be that it was 3 months to put a claim into the tribunal. That's all changed now. There's a principle called the ACAS early conciliation process, which is where you lodge an initial claim with ACAS, and ACAS will then seek to try to settle that claim with your employer. Now, ACAS early conciliation, what that does, it has the effect of ceasing the time limits from the date upon which it is started. So time stops running, in essence. You have 3 months to start your claim off, and that's 3 months to lodge the claim with ACAS early conciliation. Now, that's really, really straightforward. All you do is fill out an online claim. So the employee will say, right, I've been unfairly dismissed. I'm going to log on to the ACAS website, fill out the early conciliation form, and at that point, once that's submitted, that pauses time limits, and the time limit then stops running for the period upon which conciliation runs for. So if it lasts for the normal 4 weeks, time doesn't run for the 4 weeks. At the end of conciliation, that individual then has at very least 1 month to bring their claim into the employment tribunal. So from the date upon which they didn't settle their claim, they've then got a further month to commence that. So it puts the risk factors on for an employer to be going from what used to be a 3 month period into potentially sort of a 4 or 5 month period of time where you might receive a claim coming in. There's some kind of complicated rules about how you add time limits on, but normal cases, you either add on the amount of time the conciliation ran for onto the time limit, or you say that person has at very least 1 month from the end of conciliation to commence their claim. Now, if we just move on to ACAS early conciliation, just onto that next slide. So the ACAS early conciliation system itself was designed that when employees had to pay to put their claim in, so you used to have to pay an issue fee and then a hearing fee to start your claim off and to have it heard. The government said, well, look, to manage that process and to make sure that people can still bring their claims without fear that they're going to have to pay those fees up front, we're going to put in place a system called early conciliation. Literally just a process that is designed to allow both parties to settle the claim without it going through to an employment tribunal. Back in the olden days, back when I first started, as employers, we just literally get an ET1 through the post. You just get a claim form through. You might not even have had any impression that that individual was going to bring a claim against you. There was no requirement on them to contact you, write to you, let you know they were going to bring a claim. It could just be all of a sudden, you just got a claim slapped on your desk. That has now changed. With ACAS early conciliation, you do get a notification somewhat earlier to say this individual is going to bring a claim against you. They are looking for this as settlement. And it can allow parties to do a couple of things. You can either settle the claim at that point. It can be really, really useful because it allows you to understand what their issues are. They've got the support from ACAS, so that someone is there with them passing on offers and sort of mediating the approach between employer and employee, which can be really useful. And it does allow you to hopefully nip that claim in the bud before it gets to tribunal. It can also allow you to point out to the claimant where they're just manifestly wrong. So it used to be, as I say, you put the claim in, it could have been completely daft, nothing, no type of merits to it whatsoever. But that individual wouldn't know that. So then it gets in front of a judge, and you have to go through all the rigmarole of responding to it, saying this is a load of tosh. At least now with an ACAS early conciliation, you're able to say to ACAS, this claim is a load of tosh. we will give that individual a reference, a favourable reference, allow them to get a new job, but they really need to drop this claim against us. And that can allow you to settle it quite early on at that point. Also, it allows you to consider whether or not it will be better to settle that claim if you think you might lose in an employment tribunal. So if that person's come to you, you know you've got it wrong. There's been some major error that's gone along with the process. It does allow you at a very early stage to settle with that individual. The entirety of the ACAS conciliation process is privileged. So it's completely confidential. Neither party can refer to it during any type of open proceedings. So you could make admissions within that process. We don't normally advise that, but you can say, look, okay, we know you got this one wrong. We'll pay you this amount of money. And that individual, if they then later on decide to bring a claim against you, can't then refer to the fact that you have tried to settle that with them through ACAS. The only thing that is disclosable throughout the ACAS process is the fact that conciliation actually took place. It is our requirement. Every employee must contact ACAS before making a claim. They have to do it. It's part now of the process, and they have to get the early conciliation certificate number to allow them to bring the claim against their employer. So all that is the certificate that's produced at the end of conciliation to say that the conciliation did not reach a settlement. They then use that number that's on that certificate in order to allow them to advance the claim online against their employer. I have to say, I have found it useful over the last few years when it's been engaging with it. It does allow you to weed out those claims and or filter down, kind of narrow those issues too. If you do get a claim through, so it's called an EC1 claim form, that will be covered off a little bit later on as well. So you do get a claim through, the first port of call you've got to do is consider submitting your response. So if this comes to us, so one of our clients gets the pack of information that comes through from the tribunal, you'll have a date on what's called a notice of claim that specifies to you when you have to submit your response by. So it's 28 days from the date upon which you are sent the claim. Now, I've seen a lot of this recently, that employers just aren't getting these claims through the post or getting them quite late. Technically, that doesn't actually matter. The tribunal will consider whether or not you are able to submit a response within time, but they will try to be flexible with you if you can show that your office was closed, you didn't receive it, it was sent to the wrong address, that type of thing. What we do as lawyers is we get a claim in, we consider a few things. So we look at the actual prospects of success for it. So whether or not we think this claim has actually got any merit to it whatsoever, whether it's got arguable grounds to it, or whether or not we think it might actually succeed. We look at an overall cost analysis of that. So that includes legal costs, the fees that you're going to have to pay to a solicitor to defend it for you, the management time that's going to be incurred in dealing with that claim. So taking people out of the business in order to either provide us with instructions, draft witness statements, or attend at the hearings that might be listed. And also look at the pros and cons of settling it as well. Obviously, a pro of settling is normally that it just gets it off your desk. It stops it from being a distraction to trading. But obviously, a con of settling, and quite a few of my clients are quite alive to this. They don't want to set a precedent that if a claim gets put in, they always settle it. And I have a client of mine who they do care. They're a care provider, and they, as a matter of course, don't settle claims. Because they have a trade union involved, they're quite a militant trade union, and they get actions brought against them quite a lot. So what they don't want to do is have a principle where someone brings a claim against them, they automatically settle it. So they'll look at all those considerations when they first start out. You have to say 28 days to submit your response or to apply for an extension within that time. When you submit your response, the response itself should contain the answer to the allegations that are raised by the claimant. Now, the allegations that are raised by the claimant can sometimes be confused, I guess is a good way to put it, confused and misleading. They can be rambling. They can just make barefaced assertions about how awful the managers are in the business that has absolutely no relevance to the claim whatsoever. So what we do is we try and look through those claims to pick out what the actual response should be. So what is the claim that has been brought? So, for instance, I had a claim like the last few weeks or so. The individual, she'd bring a claim for unlawful deduction from wages, really, but she took it upon herself to raise 3 or 4 pages worth of awful allegations against my client that actually weren't of any relevance at all to the claim. So what we did in our response is to be succinct, brief as we possibly can, but to answer those allegations in a straightforward and professional way. If you do that, you will get the judge on your side. If the judge looks at a claim that's 4 pages long, it's full of kind of nonsense or things that don't really make any difference to the claim, looks at your response that just says, these are the facts, nice and short and sweet, this is our response to those, you automatically put yourself on the front foot because you're making it easier for the judge to find in your favour. Make sure that when you submit your response, that all the facts that you've put in there are absolutely correct. If you get something wrong, or it's inconsistent, or it's revealed at a later stage just be incorrect, you're going to look A, a bit silly, but B, it also puts into the judge's mind that you might not be telling the truth, or that you might just be simply confused about those facts. And if later on you're trying to say in a witness statement, well, actually, we are to be believed, we are, our reason for doing this wasn't nefarious, it was completely fair and reasonable, but when we first submitted our response, we actually mucked up our facts, got our timeline wrong, it was inconsistent, it puts us on the back foot. So it's important at that stage to make sure that everything runs smoothly, we've answered all those allegations, and that everything we're saying is completely correct. So that's been done. I will fire this one over to Lil to run you through the case management ones.
Thanks, Toby. That's helpful. So we're at the stage where you've had your claim come in and you've prepared your response that's been filed with the tribunal. You'll then get a confirmation from the tribunal that the response has been accepted, and either at that stage, or they might write to you separately, you will also probably get something called case management orders, or sometimes also called directions from the tribunal. It's effectively telling you what, as a party to the claim, you need to do to prepare for the hearing, and then the timeline for completing those different stages. Typically, in a quite straightforward claim, it will include a date for the claimant to provide something called a schedule of loss, which is setting out the amount that they're claiming and why. It will tell the parties when they need to exchange a list of the evidence. That's normally slightly further down the line. And that's the evidence which is relevant to the case. I'm going to go through that in a little bit more detail later on, but it's something known as a list of documents. You'll then get a date for requesting from the other party any documents that you don't already have in your possession and disclosing yours in turn to them. Preparation of a bundle of evidence for the final hearing. By bundle, I mean it's effectively one or more files of documents that contain the evidence for the hearing. Normally, not always, but normally that will be for the respondent to prepare and pay for. And then the last stage is normally the preparation and exchange of witness statements. So once both parties have all the relevant documents to the case, they sit down and prepare their witness statements, which is the factual evidence on which they want to rely. And again, I'll come back to that in a little bit. Depending on the case, especially if it's a little bit more complicated, you might also be asked to prepare a chronology of events, so a timeline for the tribunal, just to walk them through it a little bit. Maybe a list of people that are involved, sometimes called a character list. Again, if it's confusing for a judge or a panel because there's people involved, they want to have that in a succinct document before them. And maybe also a list of legal issues, sort of relevant issues to the case, or something called a skeleton argument, which is just setting out the legal structure of the case. So you'll always have the basic ones, but sometimes additional orders can be tagged on. When you receive in the case management orders, it's important to consider, and obviously this is something we'll talk you through at the time if we're involved, can you and any of your witnesses comply with the deadlines given? Are they realistic? Normally they are. Tribunal is obviously very experienced in terms of setting out quite fair deadlines, but maybe they have underestimated the volume of disclosure or something like that, and you need a bit more time. Or for instance, maybe it just doesn't fit in terms of you've got people absent from the business and that needs to be taken into account. Or are there any other case management directions that you think would be useful in the case? So again, maybe something like an exchange of a preparation of legal issues at the end, which you think would be helpful in terms of guiding the tribunal. If you do think the tribunal hasn't set out all the orders that would be appropriate, or the timing isn't quite right, we can write to the tribunal to request an extension or further orders if they are required. You might also at that stage receive your final hearing date, so in the same document that you get your case management orders. Again, when you get that date in, don't just sort of file it in a drawer, make sure that you actually look at it, note it, and consider firstly, can your witnesses attend on that date? Are any of them on holiday? Make sure you're checking straight away. Has the hearing been listed for sufficient length of time? Again, normally the tribunals are reasonably good at estimating, but sometimes they do get it wrong. Particular, you might think it is a very straightforward case that can be dealt with in a day, but have they listed it for 2 to 3 days? That has cost implications. Or vice versa, is it quite a complicated case and you know that you're going to have 8 to 10 witnesses, but they've only given you a 3 to 4 day deadline, which simply isn't going to be realistic. And are you going to need representation at the hearing, either from a solicitor or counsel, and make sure that they have that diarised in, so no one's scheduling holidays during that time. So it's, it's quite admin heavy at the start, but it's worth going through these things quite thoroughly and making any applications that you need to right at the outset. And then just moving on to the next slide in relation to preliminary hearings. So again, when you get your case management orders or in a separate letter, the judge may decide that a preliminary hearing is necessary. And it's more likely in more complicated cases, in particular discrimination cases, or if an application has been put forward by either party as part of their pleadings, so either in the claim form or in ET3. The preliminary hearing can take place in person or by telephone, then increasingly by telephone, just because it's a time and cost saving measure for everyone involved. Though sometimes the judge will want to have everyone in person. If it's a litigant in person, either not represented, the judge is more likely to want the parties to actually show up rather than be willing to do it by phone. So the purpose of preliminary hearing is just to clarify, well, it can be one of a number of points. Often they're used to clarify the issues the tribunal will need to determine at the final hearing. So in particular, as Toby said, you get in a lot of claim forms that are confusing. The claimant hasn't had any legal or the benefit of any legal advice, and they don't quite know what they're claiming. They just sense that they have a claim. So the judge will want to try and break that down at the preliminary hearing and set out exactly what the legal issues are, so both parties are fully aware in terms of what is being claimed and what needs to be responded to. The judge might also at that stage issue case management orders or additional case management orders, or amend the case management orders that have already been issued. And also sometimes they are used to explore the possibility of settlement. That might sound a bit odd once you're already in the tribunal proceedings, but there is something called judicial mediation, where a judge will effectively act as a mediator in a case outside of the normal tribunal structure. So it might be something that a judge feels is appropriate to raise at that time during the preliminary hearing, and both parties have the opportunity to consider whether they are willing, now that they're a bit more aware in terms of what's being claimed, to sort of step outside and consider a judicial mediation at that point. So we've had our case management orders, we potentially had a preliminary hearing. We're then just going to progress in terms of meeting the different deadlines that the tribunal set out. But at any point during the tribunal proceedings, right from the outset in terms of when you're putting in your original response, your ET3, up to the hearing, it's important to consider whether it's appropriate to make an additional application to the tribunal. And I just want to run you through some of the more common applications that we see, or make on your behalf. So you get strikeout orders, deposit orders, unless orders, and cost warnings. They're the most common terms that you'll come across. Sorry, Tom, just the next slide. It just gives it a bit more detail. So as I said, applications can be made at any stage of the proceedings, and it's always something to bear in mind in terms of whether it's an appropriate time to do it. A strikeout order is the most onerous of the bunch. They're hard to have granted, but it does happen. And it's important to be aware in terms of when it might be appropriate to put that kind of application in. If nothing else than just to put pressure on the other party in terms of making the point that you don't think that their claim is one that should be run. A judge will only order a claim or potentially a response to be struck out either in its entirety or just in part in terms of a particular heading of the claim if one of 4 sort of headings are met. And again, each one is quite a high threshold in terms of justification. So firstly, if you can show that the claim or part of the claim is scandalous or vexatious, they're given really narrow meanings by the tribunal. Scandalous is effectively being able to show that the claim is a blatant misuse of the legal process, and vexatious again, generally means that there's little or no basis in law for the claim. So the effect of the claim is to subject the defendant to huge inconvenience and expense, either where there's no basis in law for it at all, or there might be some basis, but it's out of all proportion to any likely gain by the claimant. So effectively, you're trying to make the argument that it's an abuse of the process of the court or the tribunal in terms of the claim being brought. So it's a high threshold in terms of being able to achieve that. Alternatively, you could argue that the claim has no reasonable prospects of success. Again, it's only in quite exceptional cases that this will be granted, or the claim will be struck out on these grounds without the judge having the benefit of actually testing the evidence during the hearing, but it does happen. The tribunal should not strike out a case for this reason unless the facts, as alleged by the claimant, disclose really no arguable case in law. There's nothing there, or the claim simply falls outside of the jurisdiction of the tribunal. So, for instance, for an unfair dismissal case, because they're often very fact sensitive, if there's any dispute in terms of the facts that are being presented by the claimant, a judge will be really reluctant to say there's no reasonable prospects of success, because they will want to test that dispute, they want to assess the evidence for that dispute before they make their determination. It can be slightly more likely for a discrimination whistleblowing claim if the claimant simply got the law wrong. And it's very obvious to everyone involved the law is wrong in those cases. But again, a judge will consider it to be a matter of public interest that tribunals have the opportunity to actually examine the merits and particular facts of the case. So unless there's a blatant mistake, it is hard to have that application granted. But again, it's always worth considering whether it's appropriate to put it in, just to put the claimant on notice that you feel that their claim should be dismissed on those grounds. A slightly more common way of getting the application through in terms of strikeout is to argue that the other party has failed to comply with orders. The main question for the judge to assess will be, is it still possible to have a fair trial of the issues, given the other party has continually failed to do whatever they're supposed to do in terms of preparing for the hearing. I mean, the main consideration is the overriding objective to do justice between the parties. So they will always look to see whether a lesser remedy is appropriate, like a deposit order, which I'll come on to in a moment. But occasionally, if there has been a significant and continuing breach by the claimant in terms of just ignoring the tribunal directions, a judge may get to the point where they say, fine, enough is enough, we will strike out on these grounds. Often the question will be, is the claimant actually actively pursuing the claim, or have they just lodged it and then not bothered to do anything after that? And I said, eventually a judge will draw a line, though frustratingly, it's often quite close to the hearing when they'll decide to strike it out on that basis. And lastly, you can argue for strikeout on the grounds that it's no longer possible to have a fair hearing. A judge will usually consider in these kind of circumstances that they'll sort of look at the behaviour of the parties in terms of how they've conducted the case. So has the party themselves or the representative behaved in a scandalous or really unreasonable manner when conducting the proceedings? Have they withheld vital evidence, or is there anything misleading in terms of what they put forward? If they do find that because of the behaviour of one of the parties it's no longer possible to have a fair hearing, they can consider strikeout on those grounds. But again, it's probably more likely that they'd look to perhaps award costs against the party rather than have the claim struck out in its entirety. The second type of application that you might come across is a deposit order. So the tribunal has the power in some circumstances to issue deposit orders up to £1,000, which won't necessarily sound a huge amount from a respondent point of view, depending on the company, but for a litigant in person, that can obviously be quite serious and potentially dissuade them in terms of continuing with their case. The deposit order can be made as a condition for them to either continue to participate in the case or to pursue just a particular element of it, so it can be attached to a particular heading of claim that they brought. It's common, what often happens is that a party will apply for an opponent's case to be struck out, but you put as an alternative that if the judge will not grant the strikeout order, that you'd have the deposit order granted instead, with the awareness that a judge is more willing to do that than to have the whole claim struck out. So a tribunal can issue the deposit order if they consider the claim has little reasonable prospect of success. Now, clearly that's not as high a threshold as the one required for a strikeout order, where there's got to be no reasonable prospect of success. So it's much easier to evidence that argument for a judge. If the claimant has a deposit order made against them, or either party, but usually it's the claimant, and they don't then pay, then that can eventually lead to the claim being struck out. So it can be a sort of stepping stone to get to the outcome that you want. In the same vein, we often will apply for something called an unless order. What that means is we're asking the judge to say if the relevant party doesn't comply with a particular order or direction they've been given, by an extended date, their claim, occasionally their response, will automatically be dismissed on the date of non-compliance without further order. So again, rather than the judge immediately ordering for that part of all or part of the claim to be struck out, they might say, fine, we accept that you have not yet exchanged a witness statement. We will give you another 2 weeks to do it as part of an unless order. If you do not comply by that date, then we will strike it out. If they're going to issue an unless order, the tribunal will send a notice to both parties confirming that the claim or response will be struck out on those grounds at that point. So you will get notification if your unless order has been granted. There's then no need to request an additional strikeout order because the claim will be automatically struck out following the issuing of the unless order. Just as a little quirk, if that happens, the claim is said to be dismissed rather than struck out in these circumstances, which doesn't feel like such a win, but actually there's no material difference between the two. It just means that the claim comes to an end. And then finally, I just want to touch on cost warnings. So a cost order is an order that a party make a payment to the other side in respect of either the receiving party's costs incurred for their legal representation, or attaching a cost to the time that they've had devoted to the case by a lay representative. Or alternatively, it can be the cost of a party's witness expenses, if witnesses, etc., had to travel to the hearing. The interpretation of cost is really wide, so it'd include fees, charges, disbursements, any expenses, as I said, including those potentially incurred by witnesses. And a preparation time order can be made in situations where the receiving party is not represented but has spent time working on the case, and that has had a cost implication. So including, if they've had any staff members devote time to the case, or any advisors that aren't legal advisors. So it's pretty wide in terms of what you can try and claim under a cost order application. They're generally appropriate, similar to some of the grounds that I was talking through before, if you can make the argument that the other side has acted vexatiously or somehow unreasonably in their conduct of the case. So again, you've had to spend a lot more time and expense on it because they've not been complying with orders, or they look to have the hearing rearranged at the last minute in an unreasonable fashion, or if the claim has no reasonable prospect of success. So it might go hand in hand with something like a deposit order. The granting of cost orders is pretty unusual in a tribunal. So it does happen in practice, but it's not the same approach that you'll get in other civil proceedings, in the High Court, for instance, where it's almost assumed that the costs will be awarded against the loser of the case. The principle of a tribunal is generally that it should be a process that is open to everyone to participate in, irrespective of financial means. And that's part of the reason why fees were removed a couple of years ago. So tribunals are always a bit reluctant to award costs against one party in particular, the claimant, if it feels too onerous to do so. But it can be a really useful tool to serve a cost warning against the other party, to say, look, because of A, B, or C, we are going to look to try and recoup our costs in relation to this case against you, because it can dissuade them to continue with their case if they don't have a strong case to do so, or also just make them consider their behaviour a little bit more in terms of how they're conducting the case in compliance with orders. So we'll often serve a cost warning, bearing in mind it might not actually translate to the cost being awarded, but just use it as a tool against the other side. And then before I hand over to Tom, I just want to talk through disclosure and witness statements in a little bit more detail. So firstly, disclosure. The duty of disclosure in the tribunal process requires parties to provide each other with something called a list of documents, which is what I mentioned before, and that list needs to include all evidence that is relevant to the case. Bear in mind that the term sort of relevant document doesn't just include those that are helpful to your case, but also any that act against you but would support the other case. You can't cherry pick in terms of what you're choosing to disclose. You have to disclose to the other side any documents or physical evidence that are in your possession or control. So it's not anything that you just necessarily have to hand, but something that you could obtain, you could reasonably obtain. It might be part of a wider group of companies, or you have to go through and do a trawl in terms of your emails or whatever it might be, but it's not anything that's necessarily easily accessible, but anything that's either in your possession or you could reasonably obtain it. Do make sure when you get to the stage of disclosure in a tribunal that all the documents that you're disclosing remain true and accurate. They've not been doctored in any way, amended or altered. If they have, you need to go back and find the original document in terms of disclosure. So you might have already, say for instance, a claimant has put in a data subject access request. You might have taken a view in terms of some of the information that was then provided to the claimant under that, because it's different tests that's involved. But when you get to the tribunal proceedings, subject to a few exceptions, you need to make sure that those original documents in their full that are being provided to the other side. The exceptions generally involve any documents that are considered without prejudice, so particularly if they're part of settlement discussions, or privileged documents. What I mean by privileged documents is anything that either has legal privilege attached to it, so it's either part of legal advice from us to you, or you responding in turn to us, or litigation privilege, and that's when the document has been prepared for the purpose of the litigation. So anything that you've created as part of the litigation procedure, they don't have to be disclosed, and they're privileged and remain confidential to you. But generally, anything outside of that that's not without prejudice does need to be handed to the other side. And also, just as a reminder, the duty of disclosure is an ongoing duty, so it continues throughout the proceedings. So just because you're past the date, the disclosure date that the tribunal has ordered, doesn't mean you can then sort of shut your books and not worry about it. If you discover any further documents after that time, which obviously does happen quite a lot, do make sure they're being passed over to the other side. And you also might find that the claimant is coming to you and saying, I now consider this document to be relevant and this got to be relevant, and take a reasonable approach to that, unless it's getting to the stage where it's ridiculous. Generally, to avoid additional costs in terms of the argument over it, we will hand those over if they do bear relevance to the case. If a party does fail to disclose, to fully disclose what's in their possession or their control, a disclosure order can be made. So if you feel that the other side is withholding certain documents, then you can apply to the tribunal for them to be disclosed to you. If the tribunal then issues that order and the other party still fails to comply, again, that can lead to an application for the case to be struck out. And then just finally on witness statements. So we've gone through the full disclosure exercise, you're comfortable, you've got all the documents, you prepared your bundle, which said is effectively just the files of documents that you're going to require at the tribunal. And it's then important that you're sitting down and preparing the factual evidence, which you're going to rely on at the tribunal. And that's when your witnesses come in. So witness statements are usually ordered to be exchanged at least 2 weeks before the hearing, possibly further in advance for more complicated cases. And that's to make sure that both sides have an opportunity to understand exactly what factual evidence is being put forward, what to expect at the tribunal, and importantly to prepare questions for cross-examination, which is when you're grilling the witnesses on the other side at the hearing itself. The tribunal won't allow parties to change their evidence once it's been exchanged. So it is important to get the statements right. I mean, Toby talked about making sure that you're being very careful in terms of drafting your ET3, your defence at the outset. Exactly the same principle applies to your witness statements. They are key to your success in the claim itself. So you need to spend the time on getting them right at the outset. A tribunal will take a very dim view on there being factual inaccuracies in there. It is possible to correct them at the hearing through something called examination of chief, but it never goes down particularly well, especially if it's a major mistake or admission that you're having to make, and it just makes the witness look a bit unreliable. So it is important to make sure that you're setting out the accurate facts in the document itself prior to them being exchanged. The statement should be a full account of what happened. They should be detailed and thorough, and set out in the order that it happened, a chronological order. They should be clear and in plain English. It's very tempting, particularly as lawyers, to throw in the odd fancy term or bit of legal terminology to try and impress the judge, but judges do not like it. They want a witness statement that just is easy to read, especially for the panel members, that talks them through the evidence very clearly, and that's the best way to then try and get the judge on your side. Your witnesses will then need to be able to attend the final hearing. So I said right at the outset, and make sure that they can on the relevant date. If they can't, if they don't turn up on the day, the judge may either decide not to consider the evidence at all, or if they do decide to consider it, they'll certainly attach less weight to it. So the expectation is that they are there so they can then be questioned by the other side. If a witness is hesitant about attending the tribunal, and I have great sympathy for that. I was a witness in one court case, and it is an incredibly stressful experience, and a lot of them will really not want to have to put themselves through it. It is important to try and prepare them as best as possible. Now, I don't mean lead your witnesses, because we're not allowed to do that. You can't tell them what to say or how to answer a question, but you can certainly give them a heads up in terms of what to expect to try and make them feel more comfortable about the day and persuade them that their attendance is important. So advise them what to expect, walk them through the whole tribunal process, which is something that we often do as part of a witness preparation meeting. Reimburse them for any lost earnings, if they're not your current employee. If they are your current employee, make sure you're paying them when they do attend, and any expenses that are incurred. And just make sure that they're very comfortable with the contents of their statement, so that they are confident in the evidence that they're giving at the day. They have a duty to tell the truth at the hearing. It's swearing a legal oath at the outset, so it's going to be a far more stressful experience for them if anything in their statement is not true and accurate than it will be if they're just simply putting forward their knowledge of events. If a witness refuses to attend, you can apply to the tribunal for an order requiring them to do so, but I would suggest that you think very carefully about this option, and we talk you through it before we decided whether or not to go for it, because what it can end up with is a witness who is supposed to be on your side, ostensibly on your side, but actually they're incredibly damaging during cross-examination because they're so cross about being required to attend. So it's always a bit of a delicate balance in terms of whether it's worth applying for a witness order or not. So just some sort of practical tips to consider. In terms of when they're preparing the witness statement, and sometimes a witness will just prepare it themselves and then we will review it, or you will review it. And sometimes we will talk to them about the events, prepare a draft, and then they will review it, and it'll go backwards and forwards. But when they're actually going through that process, it's absolutely fine for the witness to speak to a colleague or colleagues about what happened. And they should certainly be going back through the documents, the relevant documents, and refreshing their memory. But it is important that they're only including their own recollection in the statement itself. It can be easy when you're talking to people a lot about it to blur the lines and put in information there that they can't directly recall, and that will come out as part of cross-examination. So by all means, make sure that you have refreshed yourself in terms of what happened, but make sure that your witnesses are only setting out their own recollections. It's helpful for the statement at the outset to set out a little sort of summary of A, the role of the witness, and B, a bit of knowledge about a bit of information about your business and the industry that you operate in. Don't assume that the tribunal has that. The chances are that they probably don't. And even if the judge does, any panel members might not. And as I said before, the facts should be set out in a very clear chronological order, using full names, just walking the judge through the evidence nice and simply. Use statistics and exact details where possible. It shows a sort of thoroughness in terms of preparation and is more persuasive to the judge. And always make sure that you're referring to supporting documents at the relevant stages. If you're not referring to a document that you want the judge to read in your witness statement, the chances are it will be overlooked by the judge, and they may refuse to look at it at all if they question the relevance to it. So draw the judge's attention to a particular document by referencing it in the witness statement. It sounds obvious, but use short sentences to assist the witness. Most of the time, a witness doesn't actually need to read out their statement during the hearing. It's something, it's taken as read, it's the term we use for it. But occasionally they do have to read out in full, or sometimes they might just be asked to read out parts of the statement, particularly during cross-examination. And it's far more easy for them to do so if it's in nice, succinct, short sentences, rather than some long, waffly sentences that loses everyone's attention, including the judges. And always have a thorough review of any statements before they exchange. I can't really overemphasize that enough. You need to check for consistency, both within the statements and also between the statements. You really don't want your witnesses factually contradicting each other in terms of their evidence, and to make sure that you're plugging any evidential gaps that you might have. So if one witness hasn't covered something off, is that because it's set out in detail in another statement? But obviously it's being careful not to amend the statement just to set out what we want the witness to say, because it does have to be in their own words. And then just a couple of tactical considerations. So when you're considering in terms of witnesses to choose, etc., or what to put in there, give some thought in terms of which parts of the evidence do you wish to actually focus on. Is a really key strength to your claim that you want to put in quite a lot of detail in your witness statement to make sure that you're really drawing the judge's attention to it. The statements combined have to cover every point that you want to put forward. If it's not in your witness statements, again, the chances are it won't be before the judge for consideration. And can you preempt the claimant's arguments or the other party's arguments? Is there a weakness in your claim that you can provide an explanation for in your witness statement to sort of nip in the bud any potential cross-examination the other party might have? And then lastly, who will be a strong or weak witness? You can't always tell in advance, but sometimes it is a little bit of an indication in terms of how someone will deal with giving witness evidence in person. It might be that you have a choice between a couple of people in terms of giving evidence on a particular point. And then obviously, choose the person that you think can withstand the process better and will give more clear evidence to the panel. The number of witnesses will largely dictate the length of the hearing. It's by far the sort of most time-consuming part of the hearing. So you might sort of think, right, I'm going to sort of throw everything at it. I'm going to have 10 witnesses. We're going to cover up every point in huge detail, but there is cost implications to that. Judges often don't like it. They want to have as minimum witnesses as necessary in terms of presenting the evidence. So try and think quite clearly in terms of who is actually needed at the tribunal in terms of presenting your case. And that's me in terms of witness evidence. So just handing over to Tom.
Great, thank you, Lil. That was really clear and detailed. So Lil has taken you through the process of Lil and Toby submitting a response, and then the preliminary hearings, case management orders. You've done your disclosure of documents, and you've then exchanged your witness statements with our help. You then attend the employment tribunal hearing, and as Lil pointed out, it's a really good idea to properly prepare your witnesses for that process. And a good idea would be to spend a day or half a day watching another hearing. If you've never given evidence to the employment tribunal before, that will give you a really good indication of what to expect on the day. So you give your evidence at hearing, and then the judge will give a judgment at the end of that process. And the judge will either give an oral judgment on the day or a written judgment. If there's time, an oral judgment will be provided, but often cases run over and take longer than was anticipated to start with. And that will lead to the judge reserving judgment and providing a written judgment after the event. Often this can take quite a while and be a bit of a frustrating time for the parties waiting to hear what the outcome of the claim is going to be, but judges do try and get the written judgments out within 28 days after the hearing took place itself. And the basic outcomes are the claimant wins, and the judge would then decide remedy, which is what we call compensation in lay terms, and they'll also decide whether or not to make one of the awards of costs that Lil was referring to earlier. The other outcome is that the respondent wins, and again, there might be some scope for a costs award as well if the judge finds that the claimant's case had no reasonable prospects of success or was litigated in a vexatious or unreasonable way. Whether or not the remedy is determined at the final hearing or at a separate remedy hearing will often be determined by how long the parties have. So the usual process, particularly in claims of unfair dismissal, is for the tribunal to decide remedy at the final hearing. And that means that, as well as disclosing evidence that relate to the facts of the case and the legal issues that need to be decided, the parties also need to disclose evidence about what's called mitigation, which is in essence what the claimant has done to find another job or seek another form of income since their employment terminated. And as employers, what we can do is disclose evidence of jobs that we think the claimant should have gone for but didn't. And we can then put that to the claimant in cross-examination and say, why didn't you apply for this job? On the face of it, it looks perfect for you. And we want in that process to kind of build up a picture in the tribunal's mind of a claimant who is just waiting for a payout from an employment tribunal claim rather than doing their best to find another job and what's called mitigate their loss. So that is in essence what the tribunal will be looking at remedy stage. Often we get to the point in an employment tribunal claim where the parties have taken a lot longer than anticipated to give their evidence, and therefore another remedy hearing needs to be listed further along down the line. And at that point, the parties would then need to go back and disclose further mitigation evidence potentially. And this also gives us as the respondents the chance to produce what's called a counter schedule of loss. So you might either do this before the final hearing or before a remedy hearing, but this is a document that basically responds to the claimant's schedule of loss and says, we think this is unrealistic because of these reasons. We think the claimant's best case scenario is much, much less than what the claimant says. And that gives you then the chance to argue for a reduction in compensation at a remedy stage. So at the remedy hearing, there will be case management orders potentially for the exchange of mitigation documents, as I've said, and there'll be time frames for compliance with those orders, and potentially if it's a separate remedy hearing, you will have a separate remedy bundle. So that being a file of documents that are numbered in chronological order, including things like the claimant's wage slips from his new employment and his employment with you or her employment with you. And this also gives us the option to request further evidence of mitigation from the claimant if we don't think the claimant has done sufficient amount of work in terms of looking for another job. So again, we go when we're preparing for a remedy hearing, we go through the same process with you that we do in preparing for a final hearing. Once we have the date of a remedy hearing, we need to have that fixed in the diary of any witnesses that will be attending to give evidence about remedy. and we need to consider who might want to attend to give witness evidence at a remedy hearing. Often it's quite hard to give evidence about what the claimant should and shouldn't have done, but it's important, building on what Lil said earlier, that if you've got documents in a remedy bundle, it's important to have a witness statement to tie those documents together, because technically, if you don't mention those documents in a witness statement or draw the tribunal's attention to them, then the tribunal aren't necessarily going to read those documents and take them into account when deciding what remedy to award the claimant if the claim is successful. There might be another opportunity as well when we're preparing for a remedy hearing to seek further legal advice. At this point, the respondent has lost the claim, and therefore the advice would often be around what a realistic settlement might be, whether the costs of attending a remedy hearing could be avoided, and you would look at both those things when you take into account whether or not to try and settle the case at this stage with the claimant. Truthfully, this is something that should be avoided. Hopefully we will have gone through this process with you at the start of the claim. When we first get the claim form in, we'll have formed at this point a good understanding of the reasonable prospects of success, whether the claim has any merit, and we would therefore have taken all of these factors into account when deciding whether to settle it at the outset, which is sensible process to go through at an early stage as possible. Really, when you've got to the remedy stage, you know, you've already lost the case, and so this is something that you should really try and avoid, and taking early legal advice can definitely help you do that. So, potential awards. The tribunal's primary remedy in an unfair dismissal case is reinstatement or re-engagement. So reinstatement is reinstating the employee back into their old role, and re-engagement is re-engaging the employee with the employer, but in a different role. Now, this hardly ever happens. I've only actually been involved in one case where I was for the claimant many years ago, and we managed to get her reinstated into her role. And that really is a rarity, because often the claimant doesn't want to be reinstated by the point that they've brought a tribunal claim and they've gone to a final hearing, and they've been cross-examined by the solicitor for the employer. They really had enough of their employer. But sometimes, particularly where it's a job that is almost unique and a job that the claimant really enjoyed doing, and they're a specific kind of character, they want to go back into that job, you know, with their head held high, saying, you know, I've won and I'm back. And so that can sometimes be quite a powerful thing for a claimant to assert in a claim form, because obviously that's a nightmare scenario for an employer. But often, for obvious reasons, it hardly ever happens. A tribunal will only reinstate or re-engage a claimant where it's requested, and it's not often requested, but if it is, a tribunal will only award it where it's reasonably practicable to do so. And if the relationship has broken down or the role no longer exists, then it's very difficult for the claimant to say, well, it's reasonably practicable to reinstate or re-engage me with that particular employer. If it does happen and the employer then doesn't reinstate or re-engage when ordered to do so by the employment tribunal, there can be further compensation, and it's a minimum of 26 weeks gross pay, a maximum of 52 weeks gross pay on top of what the tribunal had awarded previously to the claimant after the final hearing. And that was exactly what happened in the case that I was talking about earlier, where we got reinstatement for the claimant, and then the employer didn't actually reinstate when ordered to do so by the tribunal. So then there's an automatic additional 6 months pay. So this is a really a situation that is very rare, but also one that you should be aware of, because a canny claimant with good legal advice might well ask for this to happen in order to increase the chance of a higher settlement, because obviously this is a situation that any employer would want to avoid. Other potential awards, a basic award. So that is based on an employee's age and length of service. So it's the equivalent of a redundancy payment, and it's awarded in a claim for unfair dismissal. If you've made an employee redundant and made a redundancy award, then this is offset against the basic award. The tribunal can then order compensation, which is designed to put the employee in the financial position they would have been in if they hadn't been unfairly dismissed. So it takes into account not just loss of earnings, but loss of benefits as well. So if the employee hasn't been able to get another job with the same level of pension scheme, for example, then a tribunal can award compensation for pension loss, as well as earnings and any other benefits that the employee has lost as a result of being unfairly dismissed. The reason I mention pension loss is because that can be very significant for employers, particularly if the employee was in a final salary pension scheme. And there are very complicated pension loss calculations that we can do to try and make you aware of the potential consequences of dismissing an employee or having the tribunal award compensation in favour of an employee who is in a defined benefit pension scheme. And then obviously we've talked about cost orders already. These are rare in the employment tribunal, but can be awarded if the claim has no reasonable prospects of success, or the matter has been litigated unreasonably. And as Lil said, they can be a really useful tool in the armoury of a respondent solicitor, making the claimant aware that this is a potential option for an employment tribunal if things don't go their way. In terms of discrimination then, there's no cap on compensation for discrimination. So in ordinary claims for unfair dismissal, the cap is 52-week gross pay, or around £80,000 in terms of the compensatory award. But in discrimination, if the tribunal thinks that a claimant has been discriminated against, then there is no cap on compensation, and that can be limitless. Tribunals can also award a recommendation. So as well as declaring that the claimant has been discriminated against, they can make a recommendation to the respondent for their future conduct in respect of their employees. So this might be something like, the next time the respondent goes through a redundancy process, they need to discount all disability related absence, something like that. There was a recent case called in the Employment Appeal Tribunal called Hill and Lloyd's Bank. And in that case, the claimant wanted the tribunal to make a recommendation that the employer ensured that this particular claimant didn't work with two colleagues who it was alleged had bullied her. And if that wasn't possible, offer her a severance package, which would have been equivalent to what she would have received if she'd been made redundant. And the Employment Appeal Tribunal said, yes, that was a recommendation that it was open to the tribunal to make. So again, like reinstatement and re-engagement, this could be a good tactic that a claimant could use to say, well, actually, as an employer, we want you, the tribunal, to make a recommendation that you do this in future. And obviously that's something that we would like to help you avoid at an early stage. So we've looked at compensation and with discrimination cases, if the claimant has lost earnings or benefits as a result of being discriminated against. So for example, if they can successfully persuade a tribunal that they weren't promoted because of a protected characteristic, then there might be a loss of earnings and benefits associated with that discriminatory conduct that could be claimed as part of an employment tribunal claim. But also with discrimination cases, you could get an award of injury to feelings. That's not available in unfair dismissal cases, but with discrimination cases, if the claimant can persuade the tribunal that they've been discriminated against, then awards of injury to feelings can be made, and these can be quite substantial. So there are three ranges of injury to feelings payment: minor injury to feelings, moderate.
We lost Tom. Toby, can you hear me?
Yeah, I've got you. Unfortunately, Tom looks like he's frozen.
Talking about injury to feelings, wasn't he? Just until Tom comes back, I'll cover off the last couple of points he was going to make, and then hopefully he'll be able to join us in a moment. So obviously he covered off the fact that you can get an injury to feelings award for a discrimination case, but not for unfair dismissal. And then exemplary damages, just at the end, that's effectively if the tribunal wants to go further in terms of the damages that they are awarding, based on a particular factor, particular action committed by the respondent, by the employer. So again, it's reasonably unusual, but if the tribunal is particularly appalled by the actions that the employer has conducted, then they can award exemplary damages in that kind of case. I'm just getting up I've lost Tom's slide as well. Sorry, bear with us. I think Tom's maybe crashed out. So I'll just bring up my own slides. Sorry. Here we go. And then just moving on to the end, the last slide in the pack, Tom was just going to talk you through the practicalities of defending a claim in the COVID era. Obviously, he mentioned at the start that we were seeing an increase in cases even before any of this COVID impact began to be felt, but it is likely, and we're already seeing this trickling through, that we're going to see particular cases increase. Obviously, there's been a large number of redundancies, and there's going to continue to be, especially with the furlough scheme coming to an end. So we're expecting more unfair dismissal claims off the back of redundancies, or claims in respect of arguing a failure to properly collectively consult, which is could lead to a protective award being a claim being brought by a claimant, and they can be collective claims as well, so an individual or a number of people bringing the same type of claims. And we've also had a few examples come through of claims relating to health and safety issues, so people arguing that they shouldn't have been in the workplace, or they were forced to go to the workplace, potentially leading to constructive dismissal, or the way that the furlough scheme has been applied was not done appropriately by an employer. So we are expecting an increase of anything of those types of claims, but a lot of the questions we've had recently in terms of conducting tribunal cases is, how do you do this in practice with all the restrictions that have been put in place in the last few months, particularly during lockdown? I mean, obviously things are easing slightly. We did find that most employment tribunals were quick to put in place appropriate video conferencing technology for remote hearings, so that there was still some movement in the tribunal claims, but certainly things slowed down, partly because a lot of tribunals just had a lot of their staff who weren't available for one reason or another. But there was still movement in terms of case management orders being issued, and preliminary hearings taking place, but via video conference. But we're just experiencing more delays. I mean, the tribunal system has been slow and slightly painful for the last few years, partly due to underfunding, but that has certainly increased over the last few months. But obviously, as tribunals become more comfortable in terms of the new system, then they'll hopefully clear some of that backlog. The position so far is that from the 29th of June, remote hearings were going ahead to the full hearing, either via telephone, which is slightly unusual, or more commonly via Skype video link. We are now beginning to see some in-person hearings. I think Toby had his first potentially scheduled, was it last week, Toby? Though it didn't need to take place. So we're getting a small trickle of in-person hearings, but the majority are still being listed to take place remotely. Sometimes you'll get hybrid hearings where some of it might be in person, but certain witnesses are allowed to Skype in as opposed to having to appear in person. The hearings that were postponed between March and June, where there was a bit of a full stop put on any full hearings, are being relisted now, but many of them are anywhere between the new year and 2022. So obviously that's a significant delay for those hearings that we were expecting to already have taken place. And just in terms of the practicalities of dealing with your cases, you know, if you do get a case in, it might well be that you're having to liaise with witnesses who aren't in the office in question at the time, and you're having to do that remotely. But it's just putting in place all the tricks that we've learned in the last few months in terms of how to still communicate with your colleagues remotely, keeping them up to date in terms of the hearing, just because they're not actually in the office in person. And the disclosure exercise can obviously be a little trickier if you don't necessarily have access to big company printers, etc. But the expectations are still there, and tribunals don't seem particularly sympathetic to respondents who are saying we can't comply with orders because of any of these restrictions. So it's just having a workaround, either using VC or having one person attend your office in order to prepare documents, but it's still making sure that you are complying with those orders going forwards. Tom, you reappeared. Was there anything you wanted to cover off in terms of the last slide? I've just talked through it about defending ET claims. I mean, I don't know what examples you both have about any COVID type claims that have come through.
Yeah, I mean, I think I've just learned two things. Firstly, exactly how long the battery life is on my laptop. And secondly, it doesn't give you any warning when it's about to go. So apologies for that. Just one or two observations on what you just said, Lil, about conducting employment tribunal claims in the COVID era. I've done 3 preliminary hearings via video link, and they were all really good, all really successful. And the judges have got to grips with doing remote hearings really well. And I also had a judicial mediation done that way as well. And the technology is still evolving, but I think the tribunals have done a remarkably good job, actually, of transferring online as the rest of the world has had to do. So I think Toby, you've had a couple of COVID-related cases you wanted to perhaps update on.
Yeah, I mean, I've seen the caseload I've got at the moment for tribunal claims have almost all been born out of either furlough or the health and safety related complaints. And I've got one for discrimination, a chap who was saying that he was discriminated against by being put on furlough. A couple of whistleblowing claims as well around the use of health and safety measures within a business. I've got one that's coming through as well that's in relation to a lady who didn't want to return to a workplace, and she now left on the back of that and is claiming health and safety detriment as well. So we're seeing a lot more of those types of complex claims coming through, but normally just be a straightforward unfair dismissal. This has now been chucked in as being an additional element to it. And you're right, dealing with those when potentially key people in the business aren't there, or it's difficult getting in witness statements has been challenging. But we're gonna see a lot more of those, certainly as offices start to reopen.
Yeah, great. So, Tom, do we have any questions from anyone? I know that there was one that came in advance about ACAS early conciliation from someone called Claire. Do you know if Claire is on the webinar and whether or not we've answered that part of her question? Because Toby did go into quite a bit of detail about ACAS early conciliation.
Yeah, Claire is not on the webinar currently, so I will follow up with Claire separately after.
Must have answered her question, Toby.
Yeah, so thoroughly. Yeah, was it Claire too? Done. Yeah.
Got a few in the chat box, Tom. Should I just fire them out?
Yeah.
So there was one for Toby. What does it mean to apply for further and better particulars? What does that term mean? And when would you do this, rather than, as I mentioned, just waiting for a preliminary hearing to sort out the legal issues?
Yeah, so further and better particulars is when you ask for a claimant to set out their claim better. Normally it's done where the claimant's brought some type of complicated claim, like a whistleblowing action, and they've just said something like, I said this, that was whistleblowing, but it doesn't actually fall into any of the legal grounds, or doesn't really make any sense, or they haven't said who they said it to or when they said it, that type of thing. So you'd normally do that where you want to put pressure on the claimant to actually detail out what their claim is, either because it's just something confusing, or you don't think it's got any grounds, and if you look into it, that the kind of the paper thin substance that they provided at the start will just simply fall away. I've got one at the moment where there's like 17 different allegations of discrimination across all the major grounds of discrimination, and that's what we've done. You know, the first port of call is you said this is age discrimination. We have no idea what you're talking about. Tell us more about what you mean by that. So that's when you normally do it. I normally do that within a response as well. In an ET3, I'd ask for further and better particulars. It's definitely beneficial to do that before a preliminary hearing, so that you're out in front of it, and also so that you're showing the judge what parts of the case you think are either entirely unparticularized, don't have any prospects, and you can kind of tie that into an unless order as well. So, you know, unless the claimant provides this information, that part of the claim should either be struck out, deposit ordered, or just simply not allowed to continue.
Great, thank you. There was one for me. So would you be able to recover costs from a claimant if they lie in their claim? I mean, the starting point, as I mentioned, is it is difficult in practice to recover costs, but it would fall within one of the grounds where you could make that application. So you'd argue that the claimant, in their actions, in their lying, has sort of vexatiously or unreasonably conducted their claim. So it would certainly give you a ground for the application. Whether or not you did actually get costs awarded would largely depend on the extent of the lie. You know, a very minor lie, so this is something that the claimant tries to argue was just a mistake, or was it a really big porker that had a massive impact in terms of the costs that both parties have had to bear in conducting the proceedings. So it will be fact sensitive, but it would be a possibility. In my last two hearings that have gone ahead, we've been able to show that the claimant has lied in both of them, but one of them was quite a minor point about whether or not he'd received a document. For the other one, it was really significant and lost in the case. Neither one, we got cost, but we didn't actually apply for it because the party didn't have the appetite to do it. But in the latter one, where it was really determinative in the case, and it did cause my client to accrue additional cost and time, management time, then a cost award might have been granted. And then just finally for Tom, if claimants are successful, do they just get awarded the sum they have claimed on their schedule of loss?
Yeah, it's a good question. Not necessarily. The tribunal's got a large amount of scope to award what they think is just inequitable. They will generally use the claimant schedule of loss as a starting point, and having seen a lot of schedules of loss over the years, they're normally well in excess of what the tribunal are likely to award. So I think it would be a very unlikely scenario where you would get a tribunal awarding a claimant more than what they are claiming in their schedule of loss, but it's not completely out of the bounds of all possibility. But if you've got good legal advice going into it, or you've done your counter schedule of loss, you'll understand what the tribunal is likely to award in a worst case scenario for you, and you can make your plans about the strategy for defending the claim accordingly, really.
And then just following on from that, we've had one from Mary asking, what are the current values, levels of compensation in relation to injury to feelings, for instance, minor, moderate?
Yeah, did you cover that off while I was trying to log back on?
No.
So they are in three sections. So you get minor injury to feelings, moderate injury to feelings, and severe injury to feelings. And you can get upwards of around £45,000, but officially it's uncapped. So you could, in a very severe case, get injury to feelings compensation in excess of that 45 grand limit of the upper range of injury to feelings. But it is based on how injured the claimant's feelings are. So it would be a very unusual case where not only had the respondent lost the case and been found to have discriminated against the claimant in such a severe way, but then for the claimant also to have very severe injury to feelings. They would probably have to get some form of medical report to say that it had affected, how seriously it had affected them for that kind of level of injury to feelings to be awarded. Most commonly, you will see awards for injury to feelings claims in the middle bracket. And so that's in the region of £15,000 to £25,000. And that is generally speaking because claimants, unless they've been obviously discriminated against in a horrific way, will pitch their claim in that kind of area. And so that's the kind of level of injury to feelings compensation that the tribunals are often asked to award. But it really does depend on the facts of the specific case and what type of discrimination the claimant is claiming as to what injury to feelings award is likely to be granted.
Okay, I think that was the last question.
Fantastic, thank you everybody. And we've got the next HR Matters webinar coming up next month, and we will look forward to seeing you all then. If you're signed up to our list, you'll receive an invitation to that, and we very much look forward to seeing you all again then. Thank you very much.
Thank you.